Okay, start. So that is transfer of right in the goods, and then any transfer of title in the goods under an agreement which stipulates that property in goods, that means title to the goods, ownership of the goods. Property in the goods means ownership in the goods shall pass at a future date upon payment of full consideration as agreed is supply of goods, your hire purchase transactions. Okay, in hire purchase what happens? After payment of full consideration, the last installment, the title will be passed on to the buyer. Until then, it will be with the seller, but still it will be recorded as purchase in the books of accounts of the buyer. Clear? Any doubt? Fine. Next, land and building. See, any lease, tenancy, easement, license to occupy the land is a supply of services. You are not transferring the land itself, but you are giving it for rent or for a long term lease or for rental purposes. It is a service. Then, any lease letting out of the building, including a commercial or industrial or residential complex for business or commerce, either wholly or partly, is a supply of service. Okay, first one is land, second one is buildings. Fine. In these two cases we are not transferring. If you are transferring a building, it is an immovable property, not taxable. If it is a transfer of land, it is an immovable property, not taxable, because what is taxable under the GST law? Goods and services. Next, job work. Do you know what is job work? Job work, huh? For example, these gold manufacturing companies are there, okay, or even your big shops. If you order, they will prepare and give it to you. How they will do? They themselves may not do. They will send the raw gold to the goldsmith. The goldsmith will manufacture the ornament and send it back to the principal. Okay, he is called principal who is sending the goods, raw gold, and the person goldsmith is called job worker, and the work that he is doing is job work. It is a service, obviously. Service or not? Service. So in all manufacturing industry, it is not that everything they manufacture themselves. The Colgate is there. It is not that they manufacture their entire production. Some part of it will be outsourced. They will do the manufacturing activity for some charges called job work charges, and they will send it back. Entire industry runs like that. No one will manufacture fully their own products. It's the brand. Schedule 3. Schedule 2. Goods forming part of the assets of a business. Goods forming part of the assets of a business are transferred by the owner of the business or a person authorized by him so as no longer to form part of those assets. This is permanently transferring certain goods. Will it be called goods, supply of goods or supply of service? It's directly selling the goods. So it is a supply of goods. Like if a bakery is there selling their unused or old ovens, cookers, and all to a restaurant. It's a service. It may be sold by him, that is the point, or by a person authorized by him. Okay. Next, goods held or used for the purpose of business are put to private use or for any purpose other than business use. For example, I bought this laptop. It should be used for the purpose of the business, and I claimed ITC also. No, my son should not use this for his gaming purposes or watching movies and all. Then it becomes business asset put to private use. That is also taxable. And it is says it is a service. You are providing service to your son. Your business is providing a service to your son. Similarly, office car, office vehicles, etc., used for personal purposes. That is what is covered here. Then, where a person ceases to be a taxable person, either he stops or he goes below 20 lakhs limit. Now there is a up to 20 lakhs you need not register with the department. Okay, but once you cross 20 lakhs you need to register. And again, if you come below 20 lakhs and you think that you will never cross 20 lakhs, or if at all crosses I will see, then you may apply for cancellation. That means you are becoming, you are ceasing to be a taxable person. You are no longer taxable, or your product become exempted. You're dealing with one product, now it is suddenly government said it is exempt. Okay, forming part of the business shall be deemed to be a supply, even if he is not physically selling, just keeping with him, but deemed to be supply of goods. He has to pay the tax. Either he should sell and pay tax, or even if you don't sell also, you should pay tax. Unless two exceptions. One, the business itself is transferred as a going concern to another company. It's fine. Then he will sell, there I will get the tax. But you cannot keep with you, saying that I stopped business. No. And the business is carried on by a personal representative who is deemed to be a taxable person, or it is being carried on by a legal representative, etc. Even in that case, the business is continuing. See, the aim is the business should not stop. If it stops means, and you are cancelling your registration means, on the goods lying, you have to pay tax and go out. Next, supply of services, renting of immovable property. Okay, for example, this premises we have taken on renting. It's a service. Now let us see the second one. Interesting. Construction of a complex or a building or a part thereof which are intended for sale. I'm constructing an apartment, 10 floors, 10 flats. What for? Not for my purpose. It is not that I have 10 brothers, we stay there. No, no, no. It is intended for what? Intended for sale to a buyer. Is deemed to be a service. Generally, what we are saying, immovable property will not come within the GST purview. Correct? And what is this construction of a building? Is an immovable property, but it's an exception. It's a fiction created by law. It says if it is an complex consisting of units, whether residential complex or commercial complex, but which is intended for sale. From the very beginning, you know that it is for sale. They are deemed to be a service. You are deemed to be providing a service. If you observe, sorry, here also there is a material component, labor component, correct? In this, they use cement, steel, iron, etc., and labor, engineering services, auditor services. But here they are saying it is a deemed to be a service, not sale, service. And note that it is an exception. Para 5B, very important, very, very, very important for exams, even in the practice. Okay, para 5B. But there is an exception. Such sale should happen before the building gets completion certificate. When you are constructing a residential complex or commercial complex, what first step is, you will go and obtain the municipal approval. Okay, you have to go for building permit order. You will have a builder license. You will go to municipal or town planning office, whoever is concerned. You will apply for building permit order. You will prepare a plan. How many square yards? What are the setbacks? How much built up area will come? How much carpet area will come? How many floors in each floor? How many flats in each floor? Whether they are for residential purpose or office purpose? How many bedrooms? Where? How many kitchens? Whether it's a duplex? Everything plan. You know the plan, no? Plan and submit. Then they will see and approve it if everything is fine according to the rules. Then you will start the construction. Once the construction is fully complete and the municipal authority feels that it is ready for occupation, What do you mean by ready for occupation? Electricity is there, lift is operational, water is coming, construction is fully complete. So a family can come and start living. If they feel like that, they will issue a certificate called completion certificate or occupancy certificate. The sale should happen before this event. The sale should happen before this event. Even if part of the amount received also enough, it is taxable and it will be treated as a supply of service. But if the entire consideration is received after the building gets completion certificate, it is not taxable. Because according to them, the moment it gets completion certificate, it becomes immobile property. So after that, if you sell, it is not taxable. So you should start selling the respective apartment before that apartment gets the completion certificate. Take a case, 1 crore is the flat sale price. Tomorrow is the date of occupancy certificate. Today I received 1 rupee and we entered into a formal agreement or a small receipt also. You have received 1 rupee towards the advance for so and so floor. By this time, is the building gets OC occupancy? No, taxable. Because what is using the word except where the entire consideration has been received after issuance of completion certificate, except means in that case it is not taxable, in any other case it is taxable. So occupancy certificate is the point. If you have received total consideration after this event, not taxable. It's not a service, it is an immobile property, sale of building, no. But if you receive even a 1 rupee or full, whatever part or full consideration before the OC, you're out, it is tax. Clear? So definitely there may be an examination question on this. You will give buyer details, seller details, flat details, date of occupancy. Yes, taxable on entire value. So once taxable means entire thing is taxable. Okay, but it's a good question. Entire, it is not that I received only 1 rupee before OC, so I will pay tax only on one. Whatever the amount received after OC, I will not pay. No, entire amount is taxable even if it is received after the building gets the occupancy certificate. Clear? Fine. Any doubt on this? This is important. Next, temporary transfer or permitting the use or enjoyment of any intellectual property right shall be deemed to be a service. What is IPR? Intellectual property. Your mind assets. You created a song, composed a song, or you written a lyric, or you written a poem. You may take a trademark. You may take a copyright. Right? See, if you see standard textbooks, there will be a C with rounding, and they'll say all copyrights are reserved by the author. Nobody can take, copy, or reproduce anywhere else. Huh? Because that is his baby. He will have all the rights if he reserved it under the Copyright Act, IPR. Okay. So that kind of thing, if you are temporarily transferring, it is not you're leaving. If a song composed by A.R. Rahman is fully transferred to the producer of the movie, that's a different case. That will not fall here. But Rahman says, sir, for this movie, you can use it. Okay, that's all. The permanent, it will be mine only. I am not leaving it forever. Temporarily, you can use it for some period, for some movie. It is called temporary transfer of IPR, and it is a service. It is not a sale. So you may already understand this, whether it is a supply of goods or service. Still, you need to come here, check, and then apply. You cannot pay goods tax here, because in goods tariff also there will be IPR, but that is applicable only when you are sold completely. You waived off all the rights, then goods tax. But you're temporarily transferring it, then no. Next, development, design, programming, customization, adaptation, upgradation, enhancement, or implementation of information technology software shall be deemed to be a service. Some softwares are readily available off the shelf. You can go buy in the form of a CD or pen drive. You can start using it. They may be treated as goods, but you are developing. Say, I said for my organization, you are the software engineer. I asked, sir, you please come, understand our business, develop such a software which can be exclusively used by my organization. It is not suitable for others. It is not tailor made. It is not MS Office, which can be bought off the shelf and readily usable by any person. I want a separate software suiting my requirements. So then they will come, understand the business, they design, they develop a code, they stay here, they keep on updating until the final version comes, then implement it, test run it, and once they see it is running properly, yes, take it. That is what is covered here. It is not ready-made software you are buying off the shelf. No. Okay. That may be treated as goods with HSN code. But you are engaging a software developer doing all this thing and implement, then it is a service. Next, another important point, agreeing to the obligation. Agreeing to the obligation. You are agreeing for what? An obligation to refrain from an act. What do you mean by refrain from an act? Staying away from doing it. Okay? Or to tolerate an act. Tolerate means tolerating, you'll say no, you'll see tolerating means what? You're bearing it. You don't like it, you don't want it, but still you're saying nothing doing. Okay? Tolerate to an act or a situation or to do an act. You do this. You don't want, you don't like, but you are under an obligation. There is an agreement between you two people to either restraining yourself from doing an act or to do an act or to tolerate an act. For example, if I'm taking a lecture, it's very boring. You can't bear it. You're not, your nerves are coming out. Such a horrible lecture. You want to go out. But I say, if you stay till the end of the session, I'll give each one of you 10,000 rupees. Now there is an agreement. You agreed. Now there is an agreement between us whereby I am obliging you, I am obligating you to tolerate my act. You are tolerating my act. Okay, that's why I given earth as a symbolic. So whatever we do, it is tolerating, right? Correct? Huh? Some people kisses the land, like most of the movies when they come from outside station to particular place, they kiss the land. Oh, this is my Janmabhoomi. Some people will hit the land, dwell the land, correct? But it says anything. Carry on. So when I say like this, you tolerate it, my class, be with me, I'll pay 1,000. It is a service. Actually, you are doing nothing. You are simply sitting and listening to my class, but doing nothing is doing something. That is called toleration. Or see, it is a legal concept that describes situation where someone is bound by an agreement or legal requirement to not to perform a specific action. Don't do. Don't do that act. I'll give you something. Like if I take an employee on employment, I may put a condition. Say that after leaving my organization, you should not join my competitors. You got the point? After leaving my organization, you should not join my competitors, because you may learn everything here, all the concepts, all the stuff, process. Now you will be sharing with my competitor. So my secret is going out. So I may put the condition. You should not join with my competitor. If I'm in computer industry, you should not go into computer industry. You should go some other industry. Ah, got the point? You're restrained from joining my competitor. Okay, that's the thing. Business, personal life, anything. Non-compete clause. Income Tax Act, if you read in section 28, if you're receiving something for not sharing a know-how, you have one concept. You found that how to generate a vehicle, petrol, or run a vehicle, how to run a vehicle without a petrol using a particular tree leaves. You found newly. Okay. Now the petrol manufacturer may come to you. Don't share with this. Share this with the world. Okay. It's a non-compete fees. You don't come to market with this product. No. Okay. That's all. So all these are non-competing agreements. Similarly, when you buy a goodwill of a company, after buying the goodwill and the entire business, if the promoter start doing the same business, the other party, what is the fun? Then they will go to again. People will go to them only. No. If I buy a tea brand, tea time, let us say, then I will put a restriction. You should not again use this brand name, because I bought the brand. I bought the goodwill. If you again start using it, is there any point in buying this? So I'll put a condition. You are restrained from using this brand. And then transfer of right to use any goods shall be deemed to be a service. Again, ownership will not be transferred, but right to use will be transferred. Then composite supply. These composite supplies shall be deemed to be services. Like wherever there is a material involvement is there, labor involvement is there, it is called composite service. Correct? Huh? Because composite means both are involved, both service and goods. But I am treating this as a service. I don't want to complicate it. Again, you segregate the material portion, you segregate the labor portion. In the material, you will segregate into different components of materials. You apply the rates for each goods. I don't want to complicate. Full value, I will treat it as a service. That's all. Works contract service. What is works contract service? Where material and labor is construction service. Okay, it's service. And then restaurant service. Sir, whether restaurant service is a service or sale of goods? Why? Why? Because Schedule 2 says that. That's a different story. But there is a Punjab and Haryana High Court judgment whether it is a supply of goods or supply of service. Get the point? You go to a hotel, you sit there, you'll order idli, okay? You'll get all the facilities, you'll eat and come back, you pay and come back. Now, whether it is a sale of goods or sale of service, whether you can be said to be buying idli or you're receiving a service from them. See, if you really want idli, you may ask package. So you will take the parcel, typically called parcel. See, you are going there to the hotel for the comfort, correct? For the AC, for the servants, for the all the facilities they provide. In some hotels, live music, correct? Huh? At the gate, you will have one person who will open the door for you. After eating, you will have a finger bowl. Then you will have a tissue paper. All this, you are enjoying the food, correct? Punjab High Court said it is not a sale of goods, it is a service. So all these litigations will come. That is, they put an end to litigation. They said they are the Schedule 2. That is the purpose of Schedule 2. They said It is a service, means that service, that's all. No more arguments. Okay? Okay. Now, 7.1 is over, 7.1a is over, 7.2. Again, very, very important. In the coming examination, there will definitely be a question on this. 100%. Okay? And what that point also I'll tell you. Notwithstanding anything contained in subsection 1. So as per subsection 1, if you are seeing it, a transaction, it is taxable actually. But notwithstanding subsection 1, now I am overriding subsection 1. Subsection 1 is not applicable when I am applicable. That's what it says. Notwithstanding anything contained in subsection 1. Don't see subsection 1. Please come to me. If anything is here, then follow this. Not 1, but 2. What is that schedule? 3 items. First one is activities or transactions specified in schedule 3. Read the bottom line. Shall be treated neither as supply of goods. That means not taxable. If it is covered by schedule 3, it is neither supply of goods nor supply of service. That means what? It is not covered by GST Act. Similarly, second point, such activities or transactions undertaken by the central government, state government, local authority, in which they are engaged as public authorities, as government agencies, as may be notified by the government, there should be a notification for that, shall be treated either as supply of goods nor supply of service. So if you are coming to 7.2, you are not liable to pay tax. Let us first schedule 3. First one, services by an employee to the employer in the course or furtherance, in the course of or in relation to his employment, is neither supply of goods. You cannot treat him as your service provider. He is your employee. You are paying salary. There is a contract of employment. It's a contract of service. It is not contract for service. There is a difference. Indian Contract Act. So if you are my employee, of course you will be doing something for me, for which you are getting consideration. Correct? So you are doing something, and you are getting something in return consideration by one person to another person, should be a supply. But it says no. It is neither supply of goods nor supply of service. Fine. Services by any court or tribunal established under any law. Court, high court, tribunals, district courts, they cannot be said to be providing any services to you. Not taxable. The functions performed by MPs, MLAs, don't say, sir, what they are performing. Okay, that is a different question. But functions performed by MPs, MLAs, panchayats, municipalities are not supply of goods, supply of service. They are exempt. The duties performed by any person who holds any post in the pursuance of the provisions of the Constitution of India, in that capacity, like President of India, they are also doing something. The Prime Minister of India, the Vice President of India, they are holding constitutional positions. Governor, it's a constitutional position. So their services are not supply of goods, supply of services. The duties performed by any person as a chairperson or member or a director in a body established by central government or state government. They established a body saying Central Board of Indirect Taxes, Union Public Service Commission. These are all government boards, right? Right? Now, obviously, they have to appoint somebody to look after it as a chairman, as a director of ISRO, chairman of ISRO. Neither a supply of goods nor supply of service. See, services of funeral, burial, crematorium, mortuary services, including transportation of the deceased. Sir, is it a service? See, such is the coverage of the GST law. They had to tell this specifically that this is not taxable, otherwise taxable, because a person, you will engage a person, or X will engage a person, X father dies, X engage a person for all these, doing all these things to come to prepare the body or put it in a refrigerating plant so that it can last longer, prepare makeup to the body for viewing by public, or burial as per their traditional procedures, burying the body or transporting the body from the home or from the hospital to the burial ground, or keeping the body in the mortuary. They had to specifically say it is not service, not goods. That means what? If this entry is not there, means even after death also you will be paying GST. That is the beauty of the GST. Got the point? Okay. Even if you die, you are paying GST. Okay. Fine. Next, sale of land, immovable property, building, subject to what we read today. Para 5B, construction of a complex intended for sale except where entire consideration is received after the building gets occupancy certificate. Subject to that building. For example, this is a second hand building. Exempt. No GST is payable. No. Next, actionable claims. This is examination point. Note this point. This is an amendment effective from 1/10/2023. New points have been added specifically. See, actionable claims are not taxable other than specified actionable claims. Other than specified actionable claims. This specified actionable claims is introduced from 1/10/23. We already read what is actionable claim. What is an actionable claim? It's a, see, claim means, for example, you sat in the airport, you left your mobile phone in the chair where you sat. You forgot, you left there. You left that place. You have come back. Okay, somebody is sitting there. Mobile phone is there next to him. Now what you will be doing is you are claiming it. Claiming means asking, sir, it's mine. Can you please stand up once? I'll take my mobile. Correct? It's, you are claiming it. That it is mine. It is your right because it is yours. Okay. So actionable claim means is a claim. If somebody says no, now you can go to the court of law, enforcing it legally. Enforcing it means getting it done. Getting it done. Enforcing means. So if there is a claim and it is legally enforceable in the court of law, it is called actionable claim. For example, an unsecured debt. I given him loan. He given promissory note. He is not paying me. Now I will go to the court of law. That is an actionable means action through court of law. Actionable claim. But that is exempt. That is neither supply of goods nor supply of service. But specified actionable claims are taxable. What are the specified actionable claims? Here it is separately defined. Actionable claim, okay. It is defined in section 2, 102A. They may ask you this definition. What do you mean by specified actionable claims? Means the definition starts with the word, that means only this, nothing else. One, betting. You know betting, right? Cricket betting, elections betting, okay? Casinos, okay? And then gambling. Kai Raja Kai. రూపాయికి 2 రూపాయలు, 2 రూపాయలకి 4 రూపాయలు. horse racing, lottery, or online money gaming. Here also you will win something, you can claim it. If it doesn't give, you can go to the court of law. So all are very famous games. Betting, you may bet whether today it rains or not. What is the chance of raining today? 50-50 probability, no? The concept of probability will come into picture. I think you might have read in arithmetics. Concept of probability. It's 50-50. You toss the coin, whether it comes head or tail. How do you know? 50-50. That's why they are called by chance. By chance. Probability. For that, we'll give a name called luck. Hey, you are so lucky, man. You won the toss for today's batting. You are first batting. Correct? It's a chance. It's a game of chance. Gambling. Casinos. Are you sure that you are going to win? You set for, you have sat, you people all sat for international game called cards. Correct? Are you sure that you are going to win? Some people say it involves skill. Generally, gambling means it's by chance. Correct? Huh? Some people may say it involves skill, sir. It's not so easy. I can win. I have that skill. Correct? That's why later they define whether or not it involves skill. Otherwise, they are skillful games, sir. It's not so easy. I will win by using my skills. Whether it is by using skill or not, it's a gambling. It's a taxable. That's all. You don't come and say, sir, it involves skill. Casinos, it involves skill. No. Okay. Gambling, horse racing. You know all this horse racing, no? Some 10 horses will be running. You will bet on one. We don't know whether it will win or not. It's probability. So these are all called wagering agreements. If you read Sale of Goods Act, in Contract Act, Indian Contract Act, wagering. You never read Sale of Goods Act? Wagering contracts are not there, illegal, which are illegal. Wagering agreements are illegal in some countries. Gambling, betting. Betting is legal? No. Correct? They only. Then lottery. Why so much struggle? Put down preschool, elementary school, high school, college, CA, 5 years tapas. Huh? Why? I'll buy a lottery for 100 crore. Life settle. I'll go and settle in Switzerland. It will be cool always. Okay? But you will get that. What is the probability? It's by chance. And finally, online money gaming. Now it is very popular. No, even many advertisements are also coming. I think that is not appearing. That's see people like Salman Khan and then will come play games in this. I think cricket also. What is that? Dream 11. Huh? Dream 11. I mean all those. You come with a small token of money. Go with lakhs home. Online gaming. Now many people it's an addiction. They will be in that site only. So again, betting, casino, gambling, horse racing, lottery, you have to go for dictionary meaning, but we are seeing from the childhood in the movies. Now, online money gaming, it's a recent trend. So they defined. See, where from we are coming? Specified actionable claim. What is specified actionable claim? 1, 2, 3, 4, 5, 6. Now, what is 6? See, we are in the same line, one point only. We are not that we are moving away. The term online gaming has been defined under the Act under Section 280 capital B. Online money gaming means online gaming in which players pay or deposit money. First, you have to deposit money. So, I will pay. Next, we will see means you people will be in the villages. We'll see. They'll go and sit for playing the cards, especially it's Pongal days and all. All those 3 days they will not come home also. Many people they don't come home. Or ఇది మన కోళ్ళ పందాలు, they are all classic examples. పొట్టేలు పందాలు కదా, bull fight, hen fight, they will bet. Similarly cards, you go and sit, you will say start play, we will see later. First what they will ask, huh? Table, put your money on the table. Same thing. You cannot say, sir, first play, then we will see. So after play is over, you may not be able to give money. You don't have money. What you will pay? Here also same story. You have to deposit money or money's worth, including virtual digital assets. If you go to casino, you can't roam around the casino with money, legal tender, 100 rupees, 1000 rupees notes. First you have to buy some coins. మీకు తెలియందా చెప్పండి, ఇన్ని సినిమాల్లో చూడండి కదా. You will buy what? Coins. You will be watching, no, all in English movies and all. Oh, this is all mine, all coins. They are called virtual digital asset. They are unique. Virtual digital assets. They may be in the form of bitcoins. Bitcoin money, virtual digital asset. Correct? Huh? In the expectation of winning money. Why you are putting money? In expectation of winning more money. Kai Raja Kai. చిరంజీవి బాలకృష్ణ, చిరంజీవి పెడితే రూపాయికి 2 రూపాయలు, పోతే పోయినట్టు. యువర్ ఎక్స్పెక్టేషన్ ఈజ్ 2 rupees for 1 rupee. Probability, you may win, you may not win. In the expectation of winning money or money's worth, including virtual digital assets. In any event, including game, in any event, it may be a card game, it may be a cricket, it may be X, it may be Y, hen fight, bull fight. If it is online also they are conducting, I'm saying. Those days will come. Or maybe they have already come. Okay? In any event, see the language. Including game. Dream 11 also like this only. You will win the money. See, that's a classic, perfect example. Scheme, competition. See, using the word competition. It may be involving skill, but that is why they define that, they cover that, saying that you cannot say it is a skill game. See, gambling means chance, by chance. Okay, see, money is including virtual digital assets in any event, game, etc. Whether or not its outcome or performance is based on skill. You can't say my hen is highly trained with the Chinese karate fighter. It is skilled hen or a skilled bull. You can't say that. That is why they said whether or not it is based on skill, chance, or both. Obviously, you will have some skill. People playing cards, not like people like us who don't know what is ABCD, but people are there may be experts. They may predict. Sometimes it may go right, sometimes it may go wrong. Definitely, there will be a difference between you and me and people playing for last 10 years. No? Hona? They'll do all types of varieties like this, like this, like this. But we can't even properly hold it. I don't know about you. You may be an expert. And whether the same is permissible or otherwise under any law. You can't say, sorry, it is prohibited, sir. Therefore, it is not taxable. Nothing doing. Even if it is illegal, cricket betting, illegal. But you have done it. You got caught. Department is asking, pay tax. No, sir, it is illegal, not liable to pay. No, see the definition. Whether or not it is permissible under any law, but the time being in force. Now, Story is not yet over. What is virtual digit asset? 247A. They may ask you. Definitely. Every chance is there. High probability. High probability they may ask this. What is digital virtual digital asset? See, asset you know. Digital also you know. But in what form it will be? Sometimes it may be cryptographically secured. You we all know cryptographical. Have you read Information Technology Act? You don't have the syllabus, IT Act. They are called digital certificates. You know, DSCs, huh? Digital signature certificate. They are cryptographically secured. You can't read it. Can you read your signature? No, it is coded. It is crypted. Okay, people will say no. This data is encrypted. When you are using the WhatsApp chat, it will come. One sentence will come. The conversation is securely encrypted. So once you send the data, it will be encrypted. Encrypted, unencrypted. Encrypted means secured. Okay. So it includes. Now it starts with the word include. These are alternatives to the traditional currency. When you are paying online, how can you give money to them? Can you put it in the screen? Sir, take it. 1,000 rupees note. No. When you are playing digitally, your currency should also be in digital form. So it includes cryptographically secured bitcoins or non-fungible tokens. Non-fungible means, see, fungible means replaceable with one another. Let's say we have 10 100 rupees notes. Will anybody ask, I want only that ninth 10 100 rupees note, not the first one? What is the point? Is there any point? No. Anything is having equal value. And you can give it any time to the bank and you can get another note. Or you can give it to anybody else and they will give you equal value. You can go to the shop and buy something. Yeah, why they will give only for first 100 rupees note, not ninth 100 rupees note? Correct? That is called fungible, interchangeable. But these are non-fungible tokens. They are unique. If they have given 10 in the casino, if they give you 10 coins, let's say digital coins kind of stuff, you have to again go back and give that 10 only. Got the point? That is called non-fungible, unique. That means only that, nothing else. Okay. So non-fungible tokens, all money notes and coins are fungible. That is interchangeable. You can give a 100 rupees note and take another 100 rupees note. They are called fungible. But this is what? Non-fungible shall be unique and not replaceable, not interchangeable. They are unique. There is a technology called blockchain technology. Using that, they will verify its authenticity. Okay. For digital signatures, they use encryption technology or bitcoins. For this, there is a concept called blockchain technology. It's a different topic altogether. Okay. With this, that point is over. Which point? Sixth point. We are still in sixth point of Schedule 3. Actionable claims other than specified actionable claims. What is specified actionable claims? Which is introduced from 1/10/23 is this: betting, casino, gambling, horse racing, lottery, online, money, gaming. Okay. Since that means what? Excluding it, exclude actionable claim excludes this. That means what? It is not forming part of Schedule 3. What is 6 is? Other than, that means what? Is it part of Schedule 3? No. It is not part of Schedule 3 means it may be either supply of goods or supply of service. That means taxable. Okay. Then out of 6, online money gaming they again defined. Means this. In that again virtual digit asset you are using. What is virtual digit asset? They define. With this clause 6 is complete. So for the coming examinations, clause 6, serial number 6 of schedule 3 is important. Supply of goods from a place in non-taxable territory to another place in non-taxable territory without such goods entering into India. There are show cause notices were issued. It is also lateral entry. This entry was not there from the beginning, but they introduced with retrospective effect of 1770. You are in India, you are an SSC, GST SSC, but you are involved in international trading. You buy from China and sell it to US. The goods will not come to India. Is it necessary? To sell US, it should come to India. Transportation cost. No. I will ask my seller, send it to US party. Send me bill. You will go to tea shop, sir, three friends. Sir. You will order the tea. You say, sir, serve tea to both of them. Send me bill. Correct? Then same thing. You will order China party. Okay, boss, I need 100 units of X. Then, sir, where to deliver? US. Give me the US details, party details. Okay, these are the. Then shipped to US. There he will collect the goods. So he is selling the goods. He is buying the goods, but without the goods being entered into India. If they enter into India, it's an import. Custom duty is applicable. IGST is applicable. But the goods itself are not entering into India. They are neither supply of goods. Actually, there is a supply of goods. Actually, there is a purchase of goods. But Schedule 3 says no. Got it? Next, customs bonded warehouse. See, once you import the goods into the territory of India, sometimes what may happen, either some extra process is to be done on that goods, or you don't have readily money to clear the goods. So you will ask inbound bill of entry. Generally, when you import the goods, you have to file a bill of entry. So asking permission to clear the goods. Then they will assess the thing. What is the goods? From which country it is coming? What is the rate of basic custom duty? What is the IGST payable? Is there any other duty? Then they will ask you pay this. Then you will pay and go to the appraiser. Then they say okay, clearance for home consumption. They say technically clear it for home consumption. That means in India. Now they will go this with this to the concerned party. I mean the ship agents, etc. They will deliver the goods. Over. But I don't want to clear them now. So I don't pay now. They will assess. I'll file inbound bill of entry. I'm asking permission to place these goods in a warehouse, which is in customs area. They're called bonded warehouses. Customs bonded warehouses. It's a warehouse only, but will be in the customs area. It will be in their supervision. You just like that cannot go and take those goods. All the rules are applicable. You got the point? So you find inbound bill of entry, the goods will be moved to warehouse. They are not yet imported. That is the crux. Sir, goods have physically came to India. Still, until the goods are cleared by the customs authorities for home consumption, until they clear, they cannot be said to be imported. But the goods physically, theoretically, practically, if they are in India, they reached the port of India, but they cannot be said to be imported. This is a customs law provision. But when the goods are cleared from bonded warehouse, only then the goods are said to be imported. Until then, it will be in the process of importation. Only when you file X bond bill of entry, you will go to the warehouse and file X bond bill of entry, pay the duties. Now they order cleared for home consumption. Now they are said to be imported. Until then, they cannot be said to be imported. They are still in the process of importation only. Now what they're saying, now you have sold those warehoused goods to any person before clearance for home consumption. Goods are in warehouse. Now I find a customer in India or outside India. I sold them. Now that person will come and clear the goods. Okay. So this transaction of selling the warehoused goods before they are cleared for home consumption is neither sale of goods nor sale of service. No. What is the logic? If I pay, again, if I sold, now he also have to pay because he is filing bill of entry. No, he also pay the taxes. So double taxation is happening. They said the person who sold ceases to be an importer. The person who bought will become an importer. Now he will go to the warehouse, file export bill of entry, and clear the goods. He will pay IGST, BCD, and all. You got the point? So goods imported, warehoused in custard bonded area, but before the clearance, I sold to another person. Now that person will become the importer. Now my role is over. I will go out of the picture. And the transaction, see, even though I am in India, even I am selling the goods from India to a person in India or outside India, it says it is not a goods sale, sale of goods or sale of service. Okay, fine. Popularly called as high C sales. It is similar to the previous one. But the thing is, in the previous one, the goods are already imported. And imported, we should not use the word. They reached the port and they moved to bonded warehouse. But here the goods are still in waters. See, actually what happened, the exporter outside India will put the cargo into the ship or air or whatsoever, and he will send the shipping bill to me or the documents, bill of lading. That is the title to the goods, bill of lading. Have you read Sale of Goods Act? What do you mean by document of title to the goods? For the import or export of goods, bill of lading is the document of title to the goods. Now, if you, in whose name that bill of lading, he is the owner. It need not be the original buyer. So while the goods are still in waters coming to me, in between, if I find a buyer, I find another buyer. The goods are still in waters, but now I am transferring the bill of lading. That is like nothing but I am transferring the title. While the goods are still in sea. Okay. It is called high sea sales. Since the goods are not yet imported, and now the buyer will become the what? Importer. Now I am no longer importer because I sold to another person. Now he will become the importer. He will clear. He will pay the duties. Why should I pay? So they said no. Sale of goods which are on high seas. High seas need not be in waters. Even just before clearance for home consumption, goods reached port, but you have not yet filed bill of entry. Even there also you can sell. Okay. These are the two important topics. Some questions will come. We'll just quickly go through this. First of all, 7(1)(a) says once it is identified a particular transaction is a supply of goods or supply of service, now you have to identify whether it is a, sorry, I said wrong statement. Once 7(1)(a) says once it is identified as a supply under subsection 1, now you have to identify whether it is a supply of goods or supply of service by going through the schedule 2. In that, 1, transfer of title to the goods, transfer of only possession, lease tenancy or renting of land or buildings, job work, then selling of assets, or whether by you, whether by the businessman or by third party, on your behalf or using it for personal purposes. Actually, there is no any contract between me and my son. Is there any agreement? Or he is paying something to me, but still the law says service. Then renting of immovable property, construction of a complex. This is star mark. Intellectual property, temporary. If it is a permanent, it becomes goods. Permanent are not discussed here, only temporary discussed here. Then software development, not ready-made package. Then very important, agreeing to the obligation to refrain from an act or tolerating an act or to do an act. Okay. And transfer of the right to use goods. Only right you are giving goods on your goods, in your goods, my mobiles. I'm giving only right to use. Like this, అదేంటండి అంటారు, వెహికల్స్ రెంట్, మనం వెహికల్ వెళ్ళి తీసుకెళ్ళిపోవచ్చు కదా, దాన్ని ఏంటది, జూమ్ కార్స్. Classic example. What he is doing, the owner is only giving the right to use goods for 2 days, 3 days, or whatsoever. He is not selling the car. He is not. He is giving the right to use the car. That. Then works contracts, restaurant services. Then subsection 2. It says activities covered by Schedule 3, neither supply of goods nor supply of services. Similarly, government, central government, local authority engaged as public authorities, and they'll give some licenses and all. No. First one, Schedule 3, first one, employer-employee. See, if it is going, he is going out of the employment and doing something else. We said no, he's a dancer also. She is daily coming to your home, employer home, and teaching their children dance classes. That is there anything? Is it in the course of or in relation to the employment? Is there any relation between his employment and teaching the dance to the kids? No. That is taxable. He's not talking about that. As an employee, you have a scope of work. To that only it is limited. Courts, tribunals, no. MPs, MLAs, constitutional positions, no. Burial services, no. Sale of land and building, no. Actionable claim, but specified actionable claims, yes. What is specified actionable claims? Betting, casino, gambling, horse racing, lottery, online money gaming. What is online money gaming? Online money gaming means online gaming in which players pay or deposit money or money's worth in expectation of winning money, including virtual digital assets. Whether or not its outcome is based on skill, the skill లేకపోతే by chance, I don't mind. Whether or not it is authorized by any law, whether it is legal, illegal, I don't mind. You pay GST and then go. Even in the income tax also, there is no exemption for illegal income. Then everybody will do illegal activities only if they give exemption. It is the income which is taxable, whether legal or not, I don't. That's a different department will take care of. Okay, I'll collect my tax and hand over the case to police. Okay. Then what do you mean by virtual digital asset? Either it is a cryptocurrency or uncrypted currency. Then goods you are buying from one place and selling to one country, the non-taxable territory means outside India, and selling it to a person in another country. The goods are not coming to India, so not taxable in India. And goods are imported but not cleared for home consumption but warehoused in a bonded warehouse before I file ex bond bill of entry. Okay, then and you are selling the goods to another person, he will become the importer, so you are not liable to pay tax. High sea sales, the goods are still in waters, not reached the port, or having reached not cleared for own consumption, you sold to another person, not tax. Okay, that with that we have completed our second chapter, supply under GST. Any doubts? Any doubts? Have you gone through your chapter supply of goods? Supply of goods. Have you gone through? There are some practical questions. Are you going through them?